Hello everyone, I'm George from Ireland. So this is my English law channel, and this video is about judicial review because you might know that governmental decisions can be challenged in the courts. A decision isn't automatically legal simply because it's made by the government, particularly the executive. For example, the plan to build a third runway at Heathrow was subject to judicial review, and in fact the court ruled that what the government had done was unlawful, so they weren't able to do it. The government could appeal that. So far, they haven't done it. Coronavirus has intervened. The last thing people are thinking about is expanding the number of people who can fly. Or indeed, September 2019, when the UK government prorogued Parliament, that was brought before the courts, and in judicial review, the Supreme Court struck down the governmental decision, ruling that it was unlawful, and therefore Parliament reconvened. So what are the preliminaries to judicial review? They're seeing whether there's illegality, or they're testing the legality of the act. They consider rationality, fairness, and indeed legitimate expectation. I remember the first legal case I ever sat in on when I just left school was about closing fire stations and whether this was a breach of legitimate expectation. So this is a topic within administrative law, and it's significant in terms of the Constitution. We're going to look at judicial review procedure and consider which decisions are amenable to judicial review, and there's a principle of exclusivity here. So judicial review is about control of governmental power, by which I mean the executive, to a lesser extent legislatures. And the purpose of judicial review is to uphold individual rights, or indeed collective rights, when they are breached by governmental action or sometimes inaction. And this is a way of ensuring governmental accountability. And this also encourages participation in the decision-making process by the public. Gina Miller, the redoubtable Europhile campaigner, she sought judicial review of certain Brexit processes. So a private citizen can have locus standi, though these things are rather pricey to bring before the courts. So how is this of import in terms of the Constitution? Well, Geoffrey Jewell wrote the following in The Changing Constitution. The practical implementation of the rule of law has taken place primarily through judicial review of the actions of public officials. So we have to consider some of the crucial rule of law principles. These are legality, certainty, consistency, accountability, transparency, due process, access to justice, and fairness, most of which I've adumbrated in lectures already. So we know that there's a separation of powers in the United Kingdom Constitution is perhaps not quite as stark as in the United States Constitution. And common law has developed certain controls over executive power. It is trammelled. Now, people lament this is judicial activism, especially if it's a ruling that doesn't go their way. The court struggled to maintain the right constitutional balance. People argue there's a disequilibrium. Are the judges biased? We say they're independent. Can we be certain of that? Surely we can't. They have opinions like anybody else, particularly highly intelligent people gifted in the humanities. And you think they come from a very narrow segment of the population. People on the Supreme Court, for example, they're almost all over 60. All of them so far have been white. They're overwhelmingly male. Almost all of them meet by either Oxford or Cambridge. They've all chosen to join the legal profession. That's not remotely representative of the population at large. And presumably they have a narrow sort of personality types, I would guess. Or there's certain things which is just really unacceptable in the legal profession, like I can't think of a single barrister or solicitor who for years has advocated for the death penalty. Anyway, not that they have to adjudicate on that, because it's simply completely banned in the UK on participating in it or sending anyone to face possible execution. So is it the case that the courts are intruding into the political sphere? That would be wrong, just as it would be wrong for politicians to trespass into the judicial sphere. So Lord Sumption, a most distinguished barrister, at one point the best paid barrister in the realm, spoke about this in the famous F.A. Mann lecture in 2011. Anyway, we've got to consider the context of judicial review. This is not appeal. there's often a misconception about that, is about scrutinizing the legality of decisions and not considering whether they were right or wrong or wise or unwise. Are they in accordance with the law? And this is not exactly human rights law. However, increasingly the two have, what would the word be, crossed over. Okay, under the Human Rights Act, you can challenge an act saying that if something breaches the Human Rights Act, there ought to be judicial review. Okay, so let's look at for the first few issues. A decision can be challenged only if it's amenable to judicial review. So judicial review is only the right way to challenge things under the exclusivity principle. We have to ask whether the challenger has locus standi, and sometimes the claim has to be settled within a certain time limit. So the procedure is this. In 1977, the rules of the Supreme Court were set out by Order 53. Of course, it wasn't the Supreme Court back then, it was the House of Lords. In 1981, there was the Senior Courts Act, and in 1988, there was the Civil Procedure Rules, Part 54. So this is so an administrative court, for example, a high court, is where the action starts off. This is a stage for seeking permission. And if there's a permissive ruling on the papers, as they say, then the main hearing takes place inter partes, as in sort of between the parties. So which type of decisions can be challenged under judicial review, or what kind of decisions? Okay, according to the CPR regulation 54, then the things that can be challenged, that's the Civil Procedure Rules. It says the following: CPR Regulation 54, Section 1, Paragraph 2, a claim to review the lawfulness of a decision or action or failure to act in relation to the exercise of a public function. So anyway, we have to consider the decisions which are challengeable. The general situation is it has to be a public law or a decision taken by a public body. A public body is, well, set out in other areas of law. Any emanation of the state, could be the police, could be any government ministry, and so on. So these are public law decisions, they're not private law decisions. So the tricky thing is that public bodies can exercise private law functions. For instance, employment contracts in McLaren and Home Office 1990, because contracts are usually a matter of private law. And that's different to the core public authorities as set out under the Human Rights Act of 1998. Okay, there are some things that are very obviously classic public bodies. For instance, the UK government, the Scottish government, the Welsh government, the Northern Ireland Executive, the Mayor of London, and their local governments, as in county councils, city councils, unitary authorities, and so forth. Various government agencies such as the Child Support Agency, the Highways Agency, the Passport Office, these next steps agencies, other things like the Army, the Navy, the Royal Air Force, the Royal Marines, blah, blah, blah. And now there are certain self-regulatory bodies. For example, there was and City Panel on Takeovers and Mergers ex parte Datafin PLC. That was a 1987 case. So Datafin is a leading case on this because the factors have to be taken into consideration are the following: has to be the nature rather than the source of power. That is what's meaningful. The public element is key to making it a public body. There has to be some sort of duty to the general public. We have to ask whether the power is governmental in nature. And if it is, that's one of the criteria to show that it's a public body. Another criterion, if the body wasn't there, would the government need to set it up? And if the answer to that is yes, then that's another indication that it's a public body. But lastly, is the body governed solely by private law, as in private contractual law? And if the answer is yes, then that makes it less likely it's a public body. Perhaps I phrase it the wrong way around, because then if we had yes, 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 it'd be easier to remember how to define it. So there are other ways in which the Datafin case is applied. We're asking about governmental powers. There was versus Advertising Standards Authority ex parte Insurance Services PLC. This is a 1990 case. So what advertising was allowed? Or there's another case, R and Bar Council ex parte Percival, 1990. The Bar Council is, or the General Council of the Bar is really the organisation that regulates barristers, says what are the standards to qualify as a barrister, what are our ethical standards, on what grounds can you be struck off as a barrister, and so forth. So some professions are somewhat self-regulating. Some people think that's dodgy. Okay, there's some non-public bodies which are regulatory. For example, in terms of religion, there was a case R and Chief Rabbi ex parte Wachman. I think it's Wachman, I'm not sure how to pronounce it, a 1993 case. So, the chief rabbi of the United Hebrew Congregations of the Commonwealth, or the United Synagogue as it's commonly called, that's the main Orthodox synagogue in the United Kingdom. He's not a public body, he just represents a certain segment of the community. He's not an emanation of the state. Or in terms of sport, there was R and Football Association ex parte Football League in 1993. Okay, the Football Association is regulating the sport of football in England, but that's not an emanation of the state. Or the famous Aga Khan case in 1993, he's a leader of the Ismaili Muslims, even though he's not terribly religious. Okay, the Aga Khan decision, this is R and the Jockey Club ex parte Aga Khan 1993, because the Aga Khan, he's very fond of the GGs. He's owns racehorses and so on, because he lives around Berkshire, lives around Ascot, Ascot, what is it called? Royal Ascot, that famous week in the middle of June for horse racing. So in this case, the following was decided, that the Jockey Club, it regulated an important national activity. A lot of people are glued to the Grand National or lots of other race meetings, the Derby, things like that. And there's a great deal of public interest in this, partly not just public curiosity, more like public benefit. It's of advantage to the public that racing is well regulated, functions smoothly. A lot of money is going, is riding on this, for pun intended. Okay, and it might not pass the but-for test. If it did, but for its existence, would the government have to set it up? But the powers are not quite governmental powers. And do private law remedies apply or not? So we also look at the idea of contracting out. There was R and Servete Houses ex parte Goldsmith in 2000. And in this case, there were only rights in private law, not in public law, or indeed RA and partnerships in Care 2002. And this required some extra statutory underpinning. But when they're talking about regulating journalism, there was all this talk from Chukwu Umuna, then a Labour MP, till he got turfed out in his ear, standing as a Liberal Democrat a few months ago, that there ought to be a statutory underpinning. He wanted a state-censored media. Anyway, so in this case, the Partnerships in Care case, it was therefore open to judicial review challenge because there was some extra statute governing this area of activity. Now contrast that with the Human Rights Act Section 6, or the well-known case YL and Birmingham City Council, that's from 2007. So there's also the issue of procedural exclusivity in O'Reilly and Macman 1983. Now, there was a public law decision, and it should be challenged using the procedure of judicial review. In private law matters, there's a private law cause of action, as in a reason to take out a lawsuit. Not guaranteed the lawsuit would succeed. And this is to avoid the process being abused, and in order to guarantee protections that are granted to public bodies by these rules. So it seems that there's almost a mixture between public and private law. For example, in R and Kensington and Chelsea, Westminster FPC in 1992, as in Kensington and Chelsea Borough Council. This was about a public law decision exclusively, so therefore it's definitely under judicial review. It was an issue about private law, but there was this extra public law aspect to it, and an ordinary private law action might have been acceptable. So what's been the direction of travel since then? Look at Mercury Communications and Director General for Telecommunications in 1995, or Trustees of Dennis Rye Pension Fund and Sheffield City Council in 1990, or indeed Clark and the University of Lincolnshire and Humberside in 2000. Is the university public body or not? It's difficult to say. It's got nothing to do with the state. the Civil Procedures Regulation says there has to be an overriding objective, according to Part 1, dealing with cases and deal with them, as it says, expeditiously and fairly, cost effectively and reasonably fast. Remember, justice delayed is justice denied. Just like in Magna Carta, it says, to no one shall justice be delayed, as well as denied or sold. Okay, so there are time limits on all this. According to the Civil Procedure Regulation, section 54.4, the claim form must be filed within a reasonable time frame and not later than 3 months after the grounds to submit the claim first arose. So there are some special rules. Planning decisions, it's longer, it's 6 weeks. Public procurement, as in what the public's going to buy things, beds for hospitals, guns for the army, is 30 days maximum, because often getting these things in fast is, well, time is a factor. So the Civil Procedure Amendment number 4, Rules 2013, set these new time limits for these exemptions. Okay, so can public law be used as a defence? Well, let's look at a civil law case, Wandsworth London Borough Council and Winder 1985. Or indeed in a criminal law case, Boddington and British Transport Police 1992. It seems that it can. Anyway, so there'll be another lecture on Judicial Review, Part 2, more about locus standi, who actually has a right to bring a claim. Okay, that's enough from me, so please subscribe, book online lessons with me in law. I've also got my main channel, YouTube search George from Ireland, and indeed my channel British Poesy. So I teach people all sorts of subjects: English, history, geography, religious studies, French, not just law, and I help people with documents, essays, theses, dissertations, personal statements, and so forth. I'm a tour guide in Londinium too. I'm a man of many parts. Toodle pip.